So friends, we had a little bit of a surprise today when the prosecutors in Donald Trump's New York criminal case were asked by the judge whether the September 18th sentencing date should remain in place or whether it should be rescheduled. The prosecutors said, quote, "We defer to the court." So what exactly does that mean? And what are the implications for Donald Trump's sentencing in his New York case? Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, does it feel like when it comes to Donald Trump being held accountable for his crimes, we are forever having the justice rug just pulled out from underneath us? I know. Well, now there is some new reporting about the viability of Donald Trump's September 18th sentencing date in his criminal case in New York, where he is supposed to be sentenced for his 34 felony convictions. You know, we should quit calling him 45, just start calling him 34. I'm a little frustrated. Let's start with the new reporting. This from Politico. DA Bragg takes no position on delay of Trump sentencing as judge weighs impact of immunity ruling. And that article begins, Manhattan prosecutors say they won't take a position on former President Donald Trump's bid for a delay that would push his September 18 business fraud sentencing until after the 2024 election. Instead, prosecutors working for District Attorney Alvin Bragg said they would defer to Justice Juan Merchan's discretion, acknowledging that the Supreme Court's recent ruling on presidential immunity has complicated the process and could require a delay. Merchan is the judge overseeing Trump's case. This quote from the prosecutors, quote, "We defer to the court on whether an adjournment is warranted to allow for orderly appellate litigation of that question," Assistant District Attorney Matthew Colangelo wrote in a 2-page letter to Merchan, dated Friday but publicly released Monday, quote, "or to reduce the risk of a disruptive stay from an appellate court pending consideration of that question." While the decision on timing will be up to Merchan, the prosecutor's stance appeared to increase the chances that Trump's sentencing could slip until after Election Day, a result that would ensure none of Trump's 4 criminal cases will reach that juncture, in other words, sentencing, until after voters cast their ballots. Okay, friends, now before we unpack what's going on here, let's just have a look at some of the letter that the prosecutors just filed with Judge Merchan. Dear Justice Merchan, this letter addresses defendant Trump's August 14th letter requesting an adjournment of the sentencing date. The people, meaning the prosecutors, defer to the court on the appropriate post-trial schedule that allows for adequate time to adjudicate defendant Trump's motion while also pronouncing sentence without unreasonable delay. To assist the court, we note the following points. Defendant Trump's letter indicates, for the first time, his intent to seek interlocutory state or federal appellate review before he is sentenced of any adverse ruling on his motion. It is correct that the denial of immunity from prosecution is immediately appealable, but here, in contrast to defendant Trump's criminal case in D.C., the question of defendant Trump's immunity from prosecution is not presented. The only question now before the court is whether a small subset of the trial evidence was improperly admitted in light of a brand new evidentiary rule that derives from official acts immunity, and if so, whether any error in admitting official acts evidence was harmless. Now, friends, we're going to unpack that legalese in a minute. We're going to translate it from legalese to English. Back to the letter. The Supreme Court's recent decision did not consider whether a trial court's ruling on that distinct evidentiary question is immediately appealable, and there are strong reasons why it should not be. Nonetheless, given defendant Trump's newly stated position, we defer to the court on whether an adjournment is warranted, in other words, whether to cancel or postpone Trump's September 18th sentencing date, whether an adjournment is warranted to allow for orderly appellate litigation of that question, or to reduce the risk of a disruptive stay from an appellate court pending consideration of that question. The people, the prosecutors, are prepared to appear for sentencing on any future date the court sets. And then, folks, the prosecutors turn to the logistics and the practicalities of the September 18th sentencing date remaining. And we're going to talk about the practicalities in a minute, because this may be what's really driving the prosecution's decision to defer to Judge Merchan on this question. The people, the prosecutors, are also mindful that significant public safety and logistical steps by multiple agencies are necessary to prepare for court appearances by a former president to be sentenced on his crimes, court appearances in this matter. The defendant's newly stated position concerning an immediate appeal of the court's ruling may mean that significant preparatory steps are taken, only to have such steps disturbed by appellate litigation. Based on the foregoing, the people respectfully defer to the court on the appropriate post-trial schedule. Okay, friends, let's unpack what's going on here in this letter from the prosecutors to Judge Merchan. First of all, why would prosecutors just throw up their hands and defer to the court? Judge, we defer to you. Sentence Donald Trump whenever you want. It seems a little bit unusual, a little bit odd, right? Alvin Bragg's prosecutors really did remarkable work, right? They worked night and day, aggressively, appropriately aggressively, to try Donald Trump and convince a jury to convict him of 34 felony crimes that he committed because he was trying to cheat in and steal the 2016 presidential election. Why would they just throw up their hands now and say, we defer to you, Judge Merchan, on the sentencing date? First of all, deferring to a judge, deferring to a court is something that happens in every court, in every jurisdiction around the country, every day. It is something that I did literally hundreds of times in my 30 years as a prosecutor. Let me give you a typical example of when I would defer to the court, defer to a judge. After a jury convicts a defendant, the defense attorney might stand up when the judge was asking when the parties could be prepared to go to sentencing, and the defense attorney might say, well, Judge, we could go to sentencing on September 1st or September 15th or September 30th. All of those dates are good for the defense. I would almost invariably stand up and say, Your Honor, we defer to the court. We defer to the judge with respect to the sentencing date. All of those dates proposed by the defense are fine for the prosecution, fine for the government, and frankly, any other date the court wants to set. That is when you might see a prosecutor defer to the judge, defer to the court on sort of procedural matters, housekeeping matters, setting, next status hearings or sentencing dates in a case. So not unusual to defer to the court on those kinds of matters. Of course, this feels a little bit more consequential than just your run-of-the-mill sentencing date. Ordinarily, there's not all that much riding on whether a defendant is sentenced on September 1st or September 15th. But here, the American people are thirsty for justice for the crimes Donald Trump committed, in this case against the voters of New York, trying to, rob them of the full value of their vote by cheating in the 2016 presidential election. So this is a pretty consequential sentencing date, so it feels a little unusual for the prosecutors to just defer to the court. Let me go to the legalese that was contained in paragraph 2 when we were reading through the letter, and just very briefly try to explain why the prosecutors took this position. They said, look, Donald Trump has essentially, for the first time in this newly filed letter a few days ago, basically threatened to file an immediate emergency appeal on September 16th, which is the day Judge Merchan said he will hand down his ruling on the presidential immunity issue. And I'm pretty sure it's going to be, this case can go forward to sentencing because you don't have complete presidential immunity for the crimes you committed in this case, the crimes the jury convicted you of in the New York case. And Donald Trump said, if you do that on September 16th, I will file immediate emergency appeals in both state court and in federal court. Now, it's an open question whether this is an immediately appealable issue. However, I think because it is sort of a maiden legal voyage here, and I think because the appellate courts might feel the need to just sort of slow everything down and enter a stay or a pause on Donald Trump's case and not let it go to sentencing between the 16th, when he files the emergency appeal, and the 18th, 48 hours later, when the sentencing is presently scheduled for, it's almost a certainty that one appellate court or another will probably say, wait a minute, we have to freeze everything while we deal with this emergency appeal on a brand new issue that's never been decided before because the Supreme Court just handed down this harebrained unconstitutional ruling on presidential immunity. We've talked about that before, and we'll talk about it again in the future. So I think the prosecutors are saying, listen, it's an open question. We don't think an immediate appeal can be taken of this issue because it's not really about presidential immunity. It's about whether those few items of evidence, as compared to the mountain of incriminating evidence that was introduced against Donald Trump that has no immunity attached to it because much of his conduct was when he was a candidate, not a president. But if these few little pieces of evidence violated the Supreme Court rule about what evidence can be introduced at a trial of a former president, then that error is harmless. It didn't impact the case because it pales in comparison to the mountain of incriminating evidence that doesn't enjoy immunity. And that issue, the harmless error issue, is not immediately appealable. I agree with the prosecutors on that. But because we're in uncharted waters, it's an open question, and the appeals courts will almost certainly want to just freeze everything while they take some time to figure out if that's an appealable issue, and if it is, to litigate it. So this is where we go to the practicalities, the logistics, which I think is what's really driving the prosecutors' decision here. They're saying, look, it's almost inevitable that an appeals court will at least freeze everything. So what we don't want to see happen, Your Honor, is to have all of these law enforcement agencies, state, federal, local, all coordinate for a sentencing date of September 18th. That's not going to happen because, you basically have to close down the Manhattan courthouse. You have to close down blocks of New York City. You need to get multiple law enforcement agencies involved, and it is, quite a rigmarole when the former criminal president comes to town disrupting everything. I think I'm going to call him 34 from now on, not 45. And so the prosecutors are probably just saying, listen, given the practicalities, we're going to defer to you, Judge Merchan, on whether you want the September 18 sentencing date to remain or whether the wiser course might be to just delay it, see how things sort out between the 16th and the 18th, and then we can see where we are. But here's the thing, friends. Let's end on what is a guardedly optimistic note. The prosecutors did not concede that the sentencing date should be canceled and rescheduled. No, they deferred to Judge Merchan. What does that mean? It means they didn't fight to keep it in place, but they also didn't agree with Donald Trump's lawyers that it should be canceled and rescheduled. They put it in Judge Merchan's capable hands. So Judge Merchan, we will await his decision, and we're going to jump on a Justice Matters video the minute we get that decision, see what it says. But Judge Merchan could very well say, all right, prosecutors, I appreciate that you've deferred to me. You haven't really taken a position on this. You've put it in my capable hands. The September 18th sentencing date remains. That's my decision. And that will be Judge Merchan's decision to make. And I hope he makes that decision. I don't know that I would lay my $1 maximum bet on it. You've heard me say before, I'm not a gambling man. I'm not a high roller. $1 is my betting limit. I would not place my $1 bet on Judge Merchan saying the September 18 sentencing date remains, but I might put a quarter on it. I hope that's what Judge Merchan does, because we are ready for Donald Trump to finally and completely be held accountable for his crimes. Yes, because justice matters. Friends, as always, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow. And can I ask you to hit subscribe, because the numbers are creeping up. And yes, for no good reason, I am moving in the direction of 1 million subscribers. It's always free to subscribe, nothing behind a paywall. But I would hope to ratchet it up to 1 million subscribers in the not too distant future. So if you haven't already, just hit subscribe. It's always free. Thanks, friends. I'll see you tomorrow.